Hey guys, this is Rich Klein from the Diamond Law Group. Today we're going to go over the closing process. Oftentimes I hear that closings take longer than an hour, and I wonder to myself why. We're going to go over now how to avoid your closing taking longer than it needs to. It's the lasting impression with your client. We're reliant upon them for future referrals from their friends, family, colleagues, etc. And if your closing takes longer than it should, they're not going to refer you, okay? The first thing we're gonna cover here, always be 15 minutes early. Okay, there's the expression by Vince Lombardi, the famous Packers coach, that 5 minutes early is 10 minutes late. And I agree, on time doesn't work. You have to be early to your closings. There are zero excuses to be late. Traffic is not an excuse. Traffic is predictable. Leave earlier. Weather is not an excuse. Leave earlier. If you are going to be late, make sure that you call the second you know that you are going to be late. For instance, if you type into your GPS in your car or your phone, and you see that your ETA is later than the closing time, call everyone and notify them immediately. Calling the closing when you're already 15 minutes late to say you're going to be 15 minutes late doesn't do anything. And generally speaking, when people say they're going to be 15 minutes late, when they're already 15 minutes late, doesn't mean 15 minutes. It's always way sooner than they think that they're going to be there, and it ends up being a very stressful situation that is 100% avoidable. You should never be late to a closing. What will happen is your client will be there with no legal representation, and they will feel as though they're being somehow legally disadvantaged because they don't know what's going on. Should never be there late. Next, no matter how fresh you think your breath is, somebody else may disagree. It never hurts to pop a breath mint before your closing. Once you're in your closing and everyone is there, write down their names on a piece of paper. It is embarrassing to forget somebody's name. You may think that you've been working with somebody in an office and then somebody else shows up. You're not going to be able to remember everyone's name. Just write it down. It's way easier that way. Before you begin discussing anything with your client, you should speak with them directly and make sure that they understand that if you are moving too quickly, or they don't understand, or they can't hear you, they should let you know immediately. They should not feel that they are bothering you or inconveniencing you by stopping you along the way. You should never address problems at the end. If there's a problem with the closing, that should be addressed beforehand. Nobody likes surprises. Specifically, if there is a walkthrough issue, you should consult with your client beforehand to see if the condition of the property is in an acceptable condition to them. If there is not, you're going to have to negotiate that, because if you can't, you're just simply not closing. So there's no point in signing anything or going over anything until you've determined that the condition of the property is acceptable. Common ways to resolve are a credit if the parties feel that whatever number is agreed to is reasonable. You could also hold money in escrow. Again, you need the parties to agree. Or we could agree to some type of repair after the closing. Next, explaining to your client what's actually going to happen before it happens. First thing is that there are usually 3 transactions if financing is involved. The first is with the buyer and their bank. They're going to sign a lot of documents, which we'll go over a little bit later on. The next transaction is with the buyer and the seller after they have borrowed the money. They're not there to leave with the money. They want to purchase the home. They exchange the money that they just borrowed in exchange for the deed. Third transaction is with the buyer and the seller and the title company. This is a good opportunity for you to notify your clients that they need to take out their driver's license or other type of photo ID, because the title closer's responsibility is to make sure that the proper parties are attending the closing, and they're also going to be notarizing their signature. Other responsibilities of the title closer we'll discuss later on, but this is also a good time while they're shuffling around in their pockets or pocketbooks to take out whatever certified funds that they brought to the closing. Should never happen that clients don't come to the closing with certified funds. However, sometimes clients don't understand what certified checks or bank checks mean, and they don't have them for whatever reason. If that's going to be the case, you need to find that out sooner rather than later, which is again why we're asking from the onset. Next is, after you've introduced yourself and the other parties, you're then going to want to tell your clients that we're going to speak with everyone else to make sure that they're doing what they should be doing behind the scenes. The closing is very similar to going out to eat. Magically, your soup, salad, appetizer, entree, desserts all come out when they're supposed to. The reason for that is that the chef and other staff are doing things in a priority order based upon time. That's what also needs to happen at the closing. The first and most time-consuming portion of the transaction, if a bank is involved, is the borrower signing the document. So there's going to be a few questions as to what we're going to ask the bank attorney, literally from the onset. First is, do you need funding approval? This is going to be the portion of the closing. If there's going to be a delay, that's where it's going to be derived from. Some lenders, believe it or not, in today's day and age, require the borrower to sign the documents, then be sent out to the lender in order to be reviewed from the closing. Some banks want a few documents. Some banks want all of the documents. If they need to review the documents, sometimes they'll find something wrong with them, and then this cycle repeats itself. It may also take them some time to review the documents the first time. So generally speaking, if there's going to be a delay, that's where it comes from. If that is required, if funding approval is required, we're going to sign those documents first, because while the bank is reviewing everything, then we can take care of everything else. If not, you're then going to want to ask the seller's attorney for the transfer documents, so that way you can sign them first. The reason being, that way the title closer can copy the transfer documents while you sign the loan documents. The next question is, does the bank attorney have the incoming wire that the borrower is borrowing today? If not, that is another cause for concern. Prior to getting to the closing, the buyer's attorney should be asking the lender's attorney, such as the afternoon before, do you need funding approval? Do you have the wire? If you are closing early in the morning, 10 o'clock, 11 o'clock, or even earlier, and you know the afternoon prior to that they don't have the wire and they don't have an ETA, that closing should be moved to the afternoon if possible. And that should be determined before everyone shows up at the closing. Attending a closing only to find out that the bank doesn't have money is a terrible experience. Next, just because they have the money doesn't mean the bank attorney's actually done their job and gone out and obtained the requested certified funds. They need to actually go to a bank and get those funds prior to attending the closing. Leaving from the closing to go get those checks will almost certainly delay a closing. And there's no need for it, because all of the checks should be determined beforehand, and very rarely do they change. The next question we're going to ask the bank attorney is how the borrower should sign their name. Most people don't sign with a middle name or middle initial. Part of the problem is, though, that when they apply for their loan, they consider this to be an important legal transaction, and they use their God-given name, which may include middle initials or middle names. If that is the case on the loan documents, they should be signed with the middle name and with the middle initial, even though the borrower does not traditionally sign like that. But that should be verified with the bank attorney before you start signing the documents. The couple of exceptions to that is that if on the driver's license or other photo ID, the penmanship, the signature is illegible, then you can get away with saying that the middle initial or middle name doesn't need to be used because you can't even read what the borrower is signing. Next, we're also going to want to make sure that it's black ink. Some banks out there, believe it or not, actually require some of the documents to be signed in blue and the rest of the documents to be signed in black. Most of the municipalities for recording deeds and mortgages want the documents to be black as well. That being said, some banks want it in blue, so you're going to want to check that before you sign all of the documents. Speaking of the documents, the package itself, the loan documents itself, could be upwards of 100 pages, and it looks intimidating to your client. You should reassure them by saying there's only 3 things that you really need to know out of all of the documents, most of which are contained on 2 or 3 documents. The first is you're going to want to know your first payment date. For instance, today is August 24th. If we were closing today, your first payment would be October 1st. And you say, well, Rich, why isn't it September 1st? That would make sense. It's not. The way that interest works and first payments work is that there's something known as interim interest that is collected from the date of closing through the end of the month. So today, if we closed, the borrower would pay closing costs of 7 days per diem interest. Then the entire month of September would go by. September's interest is due retroactively October 1st. The reason being that the lender wants all of your payments to be the same. So they collect the interim interest up front at closing. Then interest must be earned. It works the exact opposite of rent. When you rent for the month of September, your landlord's not going to say, hey, tenant, pay me at the end of the month. That's okay, right? They want their money up front. Interest needs to be earned. You need to live there. Then you pay for it the first day of the month thereafter. Very similar to staying in a hotel. Next, you're going to want to discuss the interest rate. Generally speaking, it is fixed. If it is adjustable, it would state that on the promissory note. Next is the term, also known as the time frame. Generally speaking, it's usually 30 years. It doesn't say 30 years. It'll say that you take out the loan in 2022 and the loan final payment would be 2052. So you just have to do some quick arithmetic and show your clients that it's for 30 years. Moving on that, the 3 important things we need to know. We need to know also what the payment's going to be. So everything we just discussed, these 3 items, this is on the promissory note. These are all contained on the promissory note. The promissory note, however, does not include what the actual mortgage payment will be if it is an escrowed loan. An escrowed loan means that the bank will pay the real estate taxes for whatever they are due. In Nassau County, it's due at least 4 times per year, and it covers various timeframes. In Suffolk County, at least 2 times per year. And it's somewhat confusing to the borrowers. The bank wants to make sure that the taxes are paid because tax liens are a superior lien to a mortgage lien in case there's any type of default. The reason that it's not included on the promissory note is that the promissory note itself dictates how much the borrower owes at the specified rate over the specified term. It has nothing to do with tax repayment. That is on a separate document stating that they need to include their taxes and insurance as part of their escrow payment. The insurance is also included with the payment because God forbid anything happens to the property that's catastrophic, the bank wants to make sure that they are covered because the money that they are lending is collateralized or secured by the property itself. And if the house is not insured and something, God forbid, happens to the property, the homeowner's not going to have money to pay to rehab the house, and then they're therefore not going to want to have to pay the mortgage. So the first payment is something obviously the borrower is going to want to know. It's also important to note to them that is only the payment for the first year. On their anniversary date, the payment will change because taxes usually change, unfortunately, in one direction. The rest of the documents are immaterial to the process for the most part. Well, before we go over that, here's the note. This, again, is the most important document. It has all of these important terms over here. The note itself is the promise to repay. It's literally the IOU. The mortgage, everyone's heard of the mortgage. What the mortgage says is that whoever owns the home has agreed to the promissory note being signed by the actual borrower, okay? So if you have a husband and wife that own the home, they're both on the loan, meaning that it's against their credit and their income and their assets, then they would both be on the mortgage. Sometimes, however, a husband and wife, one of them may not have the best credit and they're not going to be on the loan, but they will own the home. So in this example, let's just say that the husband doesn't have good credit. The husband and wife would be on the deed. The husband and wife would be on the mortgage. Only the wife would be on the note. The husband is agreeing for only the wife to repay the promissory note via the mortgage. So very common, people say people with bad credit, they're not on the mortgage. That's not true. If you own the home, you are on the mortgage for the most part. There are examples, very few and far between, where you have a co-borrower that's a co-signer that doesn't actually own the home. And for my example before, where I said that the husband didn't have good credit, that's known as a co-owner, non-borrower. The purpose of the mortgage itself, there's two purposes. One is that, as I said before, the money that the homeowner is borrowing is collateralized by the property itself. If the homeowner doesn't pay, the bank's going to want to recoup as much money as they can. How will they do so? Through foreclosure, okay? So what happens with the foreclosure is the bank will put the property up at an auction and they'll try to recoup as much as they possibly can. The other purpose of the mortgage is to put the world on notice that the borrower took out the loan on that date. The mortgage itself will only be released upon satisfaction of payment in full, or if you sell the property and pay in full at that time. If you take out a loan and there's a mortgage secured against the property, when you go to sell or refinance, that loan will still be of record until it is actually paid. So regarding the first payment in escrow, we had another CE course for that. That's in our catalog. You guys can check that out. I elaborated a little bit before as to the per diem interest. But if you're interested in how escrows work, we did a separate closing cost analysis continuing education course. One of the other more important documents is the CD, also referred to as the closing disclosure. The reason why it's somewhat confusing is it doesn't have to match what the actual check the borrower brought to closing. And that confuses some borrowers because what the closing disclosure says is usually less than what they actually brought to closing. The reason for that is that the closing disclosure is not supposed to be to the penny. It is supposed to avoid any surprises. And the reason we can avoid any surprises is that per the law, the borrower needs to acknowledge the closing disclosure 72 business hours prior to the closing. The 72 business hours, it does include Saturdays, does not include Sundays or holidays. If there was an issue with the closing disclosure, it should be figured out by the borrower and the bank prior to closing. There's not all too much you can do if the closing costs are wrong from the closing itself. We don't have the opportunity to review, to revise documents, and usually that will lead to an adjournment. The reason why closing disclosures don't match the actual check is because not all of the fees that are paid at closing are required to be on the CD itself, namely the buyer's attorney fee, title closer fee, sometimes there's oil adjustments. Depending on when you close, taxes that were previously unpaid by the seller may turn up to be paid at the actual closing. By way of example, if the seller's payoff bank recently dispersed their own escrow. So as you can see, the numbers can change at closing. It's not an exact science, and the closing disclosure does not need to match the check that was brought to closing. The buyer's attorney should be able to reconcile the actual closing costs to a certain comfort level with the borrower that they understand that. The closing disclosure has other purposes post-closing. The buyer should send it to their CPA because it's a taxable event, and the seller should do the same thing, more for capital gains, as well as to get a refund for the homeowner's insurance. The rest of the documents are pretty much immaterial to the closing itself. It doesn't have much bearing. The vast majority of them have already been signed. We had another continuing education course about the actual loan documents, but they include such things as the commitment, the application, locking your rate, and other various disclosures that the borrower has pre-signed electronically, typically. But even in today's day and age, with all the electronic capabilities, we still have to sign an old-fashioned version for whatever reason. Next, while the borrower is signing the documents, the other attorney, the seller's attorney, should be reconciling how much they are receiving. So from the onset, as the buyer's attorney, I would explain to the seller's attorney, this is our client's check, the rest is coming from proceeds, and show them the checks. You want to make sure that that reconciles as soon as possible, because if there's a discrepancy, that's also going to delay the closing. The sellers should also be signing the transfer documents as soon as possible. That way the title closer can copy them. The deed, you need to make sure that the borrower's names match the mortgage documents. The loan documents govern in this instance. In terms of vesting, you need to make sure on the deed how your clients are taking title. There's 3 different ways in which to do so. The easiest to explain and the most common are husband and wife. That's known as tenants by the entirety. That means that if somebody unfortunately passes away, because home ownership, when you purchase the property, has no expiration. In other words, the mortgage is maybe for 30 years, but the deed itself will continue on forever. Sadly, we don't last forever. So unfortunately, if somebody passes away, it automatically goes to the surviving tenant by the entirety. It bypasses any probate. In other words, you don't need to go to court to make that happen, and you don't have to pay any estate tax. Second way is tenants in common. By operation of law, meaning if you don't change the deed, if 2 individuals have different last names, it's presumed that they are not married. And if God forbid something happens to either of them, the property would go to their estate. It would not automatically go to the other owner of the property. If they don't have an estate, then whoever was administering the estate, as opposed to an executor, would need court approval to do whatever it is that they need to regarding the property. The other way to combine those 2 options is something known as joint tenants with rights of survivorship. And that's what you would do if you have 2 different last names on the deed to ensure that the property goes to the remaining person. And that can even be confusing, because let's just say you have somebody who didn't change their last name, but they are married. You're definitely going to want to include that language, so that way everyone's aware of what it is that they want to have happen, God forbid something happen. The deed at closing is not the original one that we give to the clients. It is merely a copy. It traditionally takes 2, 3, 4 months, depending on the season, for the deed to be recorded. During that time frame, there are clever scammers out there who will send solicitations that look very official in nature, demanding, requiring money from the new homeowner, the buyer, to send to them in order to get a certified copy of the deed. You don't need to pay for the deed after the closing. If you receive any clever solicitation stating that, You can send it to our office and we'll reiterate that. We usually give 2 copies of the deed at closing, one because it's on legal paper and most people don't have legal paper at home. And if they need another copy, the second reason is if you need to register at school, the deed is what you're going to need. One of the more common documents that you're also going to sign as transfer documents is the TP 584. That's the transfer tax document. It shows that the seller has to pay $2 per 500 of the purchase price. I always like to show that verbiage and that calculation on the actual document itself because it just shows a little bit better when you're presenting things to your clients. It's also where the mansion tax is going to be reflected, which is traditionally 1% of any property over $1 million. Finally, the worst document that the buyer will sign is putting the real estate taxes into their name, and these are all standard forms. If you are the seller's attorney, the down payment should be cut to your client or any other expenses in advance of closing. It drives me absolutely nuts when I am fully capable of going over a huge stack of loan documents and having the transfer documents signed, and we're sitting around at the closing waiting for the seller's attorney at the very end to cut checks. There's no reason for it. It should be done in advance. Nothing's going to change. You should know everything and be capable of doing that beforehand, because after you cut the checks, then you have to make copies of it, etc. Third and final transactions with the title closer. He or she should 100% verify the payoff in advance of closing. If you've ever been in a closing where the title closer is now speaking with the seller on a conference call, waiting on hold to verify how much is owed, that is a complete waste of everyone's time. If the payoff needs to be verified beforehand, the seller's attorney should be contacted by the title closer to verify that in advance. Sometimes the title closers can just call up the banks and verify it without any type of seller on the line, and that should be attempted as well. To sit at a closing and disrupt everybody by having to have this seller speak to their bank about how much the payoff is ridiculous. It should never happen. It's a complete waste of time. You're also going to want to verify with the title closer that nothing has changed, because as I mentioned before, taxes can change, and you want to make sure that whatever we have as the buyer's attorney matches what the title closer at closing has. Title closer also is going to hand out some affidavits. It's the same as a refinance, except in a refinance, there would be no attorney present, just the lender's attorney, who is not your attorney, as well as the title closer. They're very transparent for consumer advocacy purposes and pretty much self-explanatory. However, we do explain the difference between title insurance and homeowners insurance. Title insurance is set by New York State. It is highly regulated. Every company charges the same. It is based upon the purchase price. It is due one time, and that is at closing, and lasts for as long as you own the property. Homeowners insurance, on the other hand, is different. Homeowners insurance is due annually, and that covers the condition of the home itself, not the condition of title. There are other fees that you have to pay at closing, some of which are set by the New York State, like we said before, such as the mortgage tax and recording fees and transfer taxes, mansion tax. On the other side, there's something known as ancillary fees. Generally speaking, on a purchase, they should be less than $1,000. If you wanted to shop for a cheaper company, it's usually around $1,000 of potential savings you can get from one company to the next. There's also something known as the market value rider. What this states is that at the time of closing, if there's an issue in the future, which is extremely unlikely, that there is a claim to begin with, let alone a successful claim. That being said, if there was a claim, the buyer would only be insured up to the existing purchase price. If, God willing, the property increases in value over time and there's a loss at that time, they would not be covered for that new increased value. It's really a judgment call on behalf of the buyer as to whether or not they want to spend the extra money, and it's 10% of the premium. So if the premium, generally could be $2,000, it's an extra $200. Most people decline it, however. After we sign all the documents, then we go over the numbers. As I mentioned before, we had another course for that if you're interested in seeing how closing costs can be. We then go over copies of everything that they're taking with them and repeating all the documents that they've signed, so that way they can see everything in a nice, neat order. I then personally go over what they need to do after the fact. Most attorneys don't. That'll be our next continuing education course, because we're going sequentially with the order that a transaction should take place. but to give you a precursor, we cover such things as the STAR exemption, tax grievances, speaking with their accountant, signing up for auto pay, changing their driver's licenses, putting the utilities on in their name, and things of that nature, which we'll elaborate on in our next continuing education course. As you can see, closings are pretty much the same one to the next. There is zero reason it should honestly take more than 45 minutes. If everyone is on time, there's no walkthrough issues, which could also be determined hopefully beforehand. The bank attorney is fully prepared at closing, as is the seller's attorney. Whenever there's any inefficiency, that's where the closing delay is going to be. And for the most part, it's wholly avoidable. So I hope you guys found this to be educational and look forward to seeing you soon. Take care.